Be clear, be concise, and don't repeat yourself. Understand that we know the case, so you don't have to tell us what the facts are unless we ask you what they are. And understand that while you think oral argument is for you, it's really for us, because that's the only point in time where all 5 of us are concentrating on your case at the exact same moment. And we're trying to figure out where justice lies in your particular configuration. So anticipate your opponent's best argument and put forth your counter to it before it gets to be made, or vice versa. Don't denigrate your opponent's arguments, simply make the best case you can for your side of the problem, and acknowledge your weaknesses if there are any. Say, judges, this issue has never been decided in New Hampshire before, so that's a problem, but we think you should decide it our way because. Be positive about your presentations, and of course, this is never a problem, but always be polite and on time. Well, it varies judge to judge. I prefer plain English and concision, and I try to write my opinions that way. You can't always, because sometimes you're dealing with a technical problem. We had a case argued this morning concerning whether in New Hampshire there continues to exist a writ of coram nobis. So if you're talking about that, it's not going to be plain English. But to the extent it can be plain, I appreciate that. I do not appreciate briefs in which people castigate their opponents and call them names and liars. And I mean, you would be surprised at how often we see that. It's not helpful. And avoid adverbs. If I see clearly again in my lifetime, it will be too soon.